In December of 1984, more than 40 tons of methyl isocyanate leaked from a pesticide plant in the Indian city of Bhopal. The gas leak killed more than 3,000 people and caused significant morbidity and premature death for many thousands more. Today, India's Supreme Court ruled on the government's curative petition. The Indian government sought over $850 million from Union Carbide Corporation's successor firms to extend higher compensation. Now, a 5-judge constitution bench dismissed the petition. The successor firms of Union Carbide Corporation earlier said the depreciation of the rupee since 1989 cannot be a ground to now seek a top-up of compensation. The successor firm cited the 1989 settlement between the company and the government. The firms told that the court, at the time of the settlement, the Indian government never suggested it was inadequate. The Indian government wanted more than $850 million. Now, the money sought was over and above the $470 million it got as a part of the settlement in 1989. As for the government, the enormity of the actual damage could not have been properly assessed at the time of the settlement in 1989. Dismissing the plea, India's top court said a settlement can only be set aside on the ground of fraud. The court also dubbed the failure to take insurance policies as gross negligence. A sum of over $6.7 million lying with India's central bank, the Reserve Bank of India, shall be utilized by the government to satisfy pending claims. Now, this is what the Supreme Court of India has said. The survivors of the tragedy have long been fighting for adequate compensation and proper medical treatment. The then Union Carbide Corporation chairman, Warren Anderson, was the prime accused but did not appear for the trial on February 1st, 1992. A Bhopal court declared Warren Anderson an absconder. The courts in Bhopal had issued non-bailable warrants against Anderson twice in 1992 and then once again in 2009, before his death in September of 2014. For more on this, now we are being joined by Ms. Geeta Luthra, who is a senior advocate at the Supreme Court of India. Welcome to Beyond, ma'am.
Thank you.
Ms. Luthra, how do you view the Indian Supreme Court's judgment?
So, the Supreme Court judgment, actually, the moment you have a curative petition, you know that the battle is more than half lost. So very few curative petitions have succeeded because they come after an original petition, after review, and then the court hears it as a curative in rare cases. It was perhaps expected that this would be the result of the curative petition. Now, one of the main reasons that the Supreme Court has ruled and decided against interfering is that there is no allegation of fraud. They say that a settlement was arrived at several years ago, more than decades ago, and it has said that unless fraud which vitiates a settlement has been alleged, it's not going to disagree with the settlement. And this has been the general principle of law, that the amount may be low, the amount may be high. But that itself is not a ground to reopen a settlement, because then all settlements would never have finality and would be open to review. So what the Supreme Court said is the same thing which it basically says, that it has to be fraud, duress, undue influence, anything to take away voluntariness in a settlement. Now, the fact that the amount in today's day becomes lower or abysmal just because there has been inflation was for the union, when it took that amount, to secure it in such a way or to invest it in such a way or distribute it forthwith so that it could have grown in the hands of those who were the claimants or the legal heirs. So there is a 50 crore amount which is with the RBI, and the court has said that that amount should
that is the amount which is there for your disposal at the moment. Yes. Ma'am, is there any other recourse that will be taken after this for compensating the victims of the gas leak disaster?
See, a curative petition is really one which says the buck stops here. And so it's the last, really the last recourse in a court of law. There was at one time, till Ashok Hura's case came, there was no provision for curative petition. And then Supreme Court said, all right, after review also there'll be a curative petition. There's also one other aspect. There was, the court had directed government to take insurance, and that insurance was not done. If they had done insurance covers, and that would have in turn invested the monies in, then the inflation reduction of real value of the money would not have happened. So that's another point. The third, the court has said that the government should dip into its own coffers if it wants to compensate. And the government stand is really this, the union stand, that, you know, the number of people that perhaps were visualized who had died with 3,000 came out to be 590, 5,900 odd. That the number of injured were much larger. And that's why they are reopened. But the court says these are not grounds to reopen. So only, I can't see a recourse. See, at that time, the issue was that criminal proceedings should not have been closed in a civil settlement where there was liability of this nature. But that's long closed. So I don't know, this matter had come up that should criminal liability have been closed. I'm not very certain what was the result. But you know, now, even for Union Carbide, it would have exchanged hands. Today, Dow is the owner, and you know, their shareholders would have increased. How can you increase the liability on new shareholders, shareholders who've gone in for shares of a company with a view that there is a settlement and that end has happened.
So there's a lack of a fraud which can't be proven now, of course, and there are things which can't be done retrospectively.
Not been alleged,
right.
Which has not even been alleged by the union. Right. So the court says the only allegation could have been fraud, and these are the grounds on which a contract or a settlement is set aside. There's duress, there's undue influence, there's fraud, there is lack of voluntariness. All these have not been alleged by the union. The union has only said the real money has reduced and the number of claimants has increased.
Thank you for all those updates, ma'am. Yes. I think that's where the buck stops at the moment for this case. Thank you so much for all those updates.
Thank you.